Good morning. I would like to discuss with you a few basic foundation principles for legal environment of business. First of all, remember that this class has a foundation that you will understand that laws and regulations are foundations for your business. So whether you work as an employee of a business, whether you own a small sole proprietorship or a partnership, or whether you're CEO of a large corporation, these principles that you will learn in this class will apply to you. So whether you are Walmart and an employee accuses someone in your company of sexual harassment, or whether a customer slips and falls in your store, or whether you are that customer. This is a class that will help you navigate some of the issues that you can face in the legal environment of business. And so remember that laws and regulations are also fundamental in the sense that there is a protection in the law for the right of ownership. And that is a very broad concept of property. Property is not just something that is owned, but is the right of ownership. And there is a very broad definition in our current textbook of that. The right of ownership itself, if protected and enforced by a nation's laws, gives incentive for wealth creation, which helps create prosperity. We're also going to talk about some basics of how to understand the law and why stare decisis is so important here in the U.S. as a common law nation. And we're going to classify legal sources that lawyers turn to in answering legal questions and the hierarchy of those sources. Before we get to all of those details, I do want to talk about jurisprudence. Jurisprudence is philosophy that explains the origin of law and its justification. Now, there's natural law and there's positive law. Let's compare and contrast those two schools of jurisprudence. A great example to help you think about this is, what about Nazi Germany? What if a commander there tells someone in the government or a soldier to torture and kill a large number of Jewish people based on the fact that they are Jewish? Later, the person who has been ordered to do this, after doing it, is tried for a crime. What would that person argue? Well, if you put yourself in the shoes of the person who was ordered to commit this terrible act against Jewish people, that person would probably argue under positive law that their theory of philosophy of law would focus on commands of the state that are backed by punishments. They would have said, my philosophy of the law and the justification for what I did was, I was told to do it, that's the law, and I would have been punished if I had broken the law. On the other hand, the prosecution of this case would have been looking at natural law and would have said, we don't care about what your nation or your commander told you to do. Natural law would say that you know this is wrong. It emphasizes universal moral principles. So there's a big difference there in these two philosophies. And you can look at these two philosophies and sometimes see why judges make decisions the way they do. They may be applying one of these two philosophies. So under natural law, certainly torturing and killing people based upon their Jewish origins or faith would be wrong. But under positive law, at that point in time, if your commander told you to do it and your nation's laws told you to do it, then it would have excused that behavior. Other examples of natural law might be all men are created equal, those types of things. Positive law would be just stick to what the law is and don't question it, whether it's right or wrong. Now I want to compare and contrast two other philosophies, historical school and sociological school. The historical school would say, something's been working for years, why change it? It works, let's leave it alone. A great example of this might be the law of wills. This started back hundreds of years ago in England. There were people who wanted to leave property to their heirs, their spouse, their children, or maybe to someone else, and they wanted to be able to write something down saying where this property would go. At one point, this was a new concept, but then it began to work for people, began to evolve a little bit, and then basically for hundreds of years now, we've had the law of wills, and we probate estates when someone dies. The historical school would say, why change it? It's been working perfectly, so let's leave it alone. On the other hand, the sociological school would say, let's look at evolving principles to meet the needs of society. So, historical school, let's use the example of same-sex marriage. The historical school would say, no, in the U.S., marriage has been between a man and a woman only for a very long time. But the sociological school would probably say society has evolved, and now we are going to change that so that there can be same-sex marriage. That would be the type of example you could use to compare and contrast the historical school with the sociological school. Now, there's a final one here, legal realism. Legal realism is looking at what really happens in the world. So the classic example is when I'm driving to Memphis and I see a speed limit sign that says 70 miles per hour. Why would I drive 75 when I know that's breaking the law? Well, the legal realist would say, what police, administrators, prosecutors, and judges really do is they probably aren't going to punish you or even stop you if you're only going 75 instead of really going 70. And so it's kind of a way of looking at the law in terms of what realistically will happen. And so these are some good philosophies to keep in mind as you go through this class, because it can explain some decisions of judges and some things that happen. All right, we're also going to talk in this class about some classifications of law, and one is common law and civil law. Another one is public and private law. Then there's civil law and criminal law, and substantive law and procedural law. Before I go further, please notice there is one duplication here. There's civil law and civil law here. Don't confuse these two because they are two different areas of classification. The first one is dealing with civil law countries, like possibly France, for example, versus common law countries like England and the U.S. Common law countries rely on court-made decisions. Civil law countries are more looking at types of statutes or codes. On the other hand, civil law and criminal law here is dealing with classifications of law within the U.S. There are criminal cases and there are civil cases, and we'll talk about the difference in those. So don't get confused those concepts. All right, common law and civil law. Very briefly, common law emphasizes the role of judges, and we will spend a lot of time looking at judges' opinions. And sometimes the judges are very wordy, but these opinions can be very valuable. Because if a judge of the Arkansas Supreme Court, or if the Arkansas Supreme Court writes an opinion that says some legal principle, then that may be very valuable to you as a person who lives in Arkansas when you are trying to figure out your own situation. Maybe you have a similar case that you could bring in a local court, but you realize the Arkansas Supreme Court has already made a decision in a very similar case. Well, then you can look back to that common law, judge-made law, and maybe either avoid a lawsuit altogether or at least know where you stand and how likely you are to win. Civil law relies on legislation instead of judicial decisions. Let me go back for a second. Common law is the United Kingdom, United States, Canada, Jamaica, India, Nigeria, New Zealand, a few other countries. Nations not colonized by England generally observe civil law legal systems. Those are very common as well. But in the U.S., we will be focusing a lot on the common law. There's also the distinction between public law and private law. Public law can be things like constitutional law, administrative law, criminal law, things that involve the regulation of society. Private law is dealing with legal problems and issues that concern private relationships. For example, if you hit my car, I want to sue you for a tort of negligence, then that would be private law, something between two private parties or private resource relationships. And that can be contract law, property law, tort law, that kind of thing. Most of our class will focus on private law, although we will have a chapter on constitutional law, and once in a while we'll bring up some information about criminal law. Now, civil law and criminal law. Remember, there are civil law nations, those that were not colonized by England, but they are also within our common law nation of the U.S. There are two types of cases. Civil cases are what we will focus on in this class most of the time. These are things like suits for breach of contract or tort cases, when people are trying to get money, damages, or appropriate relief like that. There can also be some other relief, such as specific performance, which we will discuss. Criminal cases are prosecutor versus defendant. They're not plaintiff versus defendant. They're not me versus you. It's the government against a defendant, trying to prove the wrong against society. Let me tell you about a famous case where this would exist, result in punishment, and kind of compare and contrast these two. So let me take a second here and get to this picture. When we want to talk about criminal law versus civil law, this is a great example. You've seen pictures of O.J. Simpson. Here's one of him trying on the famous glove in the criminal case. If you're not familiar with this case, please do, you can Google it and find some information. But basically, contrasting, criminal law is when O.J. Simpson is arrested, put in jail, and tried for the crime of murder. And he was tried for that crime and eventually found not guilty, because the burden of proof was that he had to be proven guilty beyond a reasonable doubt. And there was some doubt. Things like this glove that didn't fit and those types of things introduced enough doubt in the juror's mind that O.J. Simpson was treated as not guilty and released from jail. However, later, there was a civil trial where the parents of the victims sued O.J. Simpson for money. They couldn't sue him to put him in jail, which they might have wanted to do, but they could sue him for money in a civil lawsuit, which would be based on tort. And in this case, even though O.J. Simpson had been acquitted of the crime of murder, he was held to be liable for the tort. And so he was liable to pay money to the families of the victims, which was kind of an interesting situation. But it's easier to prove. There's less of a burden of proof. In that case, the plaintiff needed to prove their case that he did the crime. That he committed the tort, not the crime. And they needed to prove it with a preponderance of the evidence. And so there's a little bit of a difference here between these two systems, or these two types of law, criminal versus civil law. So I do hope that you will remember that. Now, another place that I want to go is substantive versus procedural law. And substantive law would be, for example, what is the definition of murder? Or if the tort is the tort of assault or battery, what is the definition of that? those types of things would be substantive law. Substantive law can be contract law, tort law, criminal law, those types of things. There's another classification called procedural law. Procedural law, and again, you would see it in a case on TV, O.J. Simpson case or many others, where the lawyers jump up and they say, I object, or where maybe a lawyer fails to file some document with the court on time or in the proper format, or you will see that things are done in a certain order in the courtroom, and certain rules apply to that. Those are procedural. That is something we will spend a little bit of time on this class at the beginning so you can understand how a trial works. But most of this class will be spent on the classification of substantive law, torts, contracts, corporate law, those types of things. So anyway, I look forward to having you in the class, and I hope this general foundational information will be helpful to you. Don't hesitate to ask me if you do have questions. Thank you very much.